Good afternoon, everybody. I want to welcome students, faculty, alumni, and friends to the University of Minnesota Law School's 27th John Dewey Lecture in the Philosophy of Law. I'm Professor Kristen Hickman. I'm the Associate Dean for Research and Intellectual Life and the McKnight Presidential Professor in Law here at the Law School. It's wonderful to see everyone here today. Dean Bill McGovern sends his regrets that he's unable to be here. He's doing well, but he's recovering from minor surgery, so had to turn over duties to me. The lecture is endowed by the John Dewey Foundation and, of course, is named after John Dewey, the American philosopher, educator, and scholar. A proponent of legal realism, Dewey's philosophy of pragmatism related his conception of a moral life to a variety of contemporary social, economic, and political issues. The purpose of this lecture is for the law school community to hear from recognized leaders in the field of legal philosophy who have made significant contributions to the development of jurisprudence. Today, we are honored to have an esteemed speaker with us. Brian Z. Tamanaha is the John S. Lehman University Professor at Washington University St. Louis School of Law. Professor Tamanaha is a renowned jurisprudence and law and society scholar and the author of 12 books and over 75 articles and book chapters. His latest books include Truth About Natural Law, History, Theory, and Consequences, Sociological Approaches to Theories of Law, and Legal Pluralism Explained, History, Theory, and Consequences. Another of his books, A Realistic Theory of Law, received the 2019 IVR Book Prize from the International Association of the Philosophy of Law and Association of the Philosophy of Law and Social Philosophy. It's quite the name. As well as an honorable mention for the 2018 Prose Awards in Law by the Association of University Presses. Four of the professor's books have included international awards, or have received international awards, and his book on the rule of law has been translated into 9 languages. His impressive background in jurisprudence and law and society scholarship, along with his path-breaking and thoughtful work on legal education, are all areas valued by the Minnesota law community. Today, Professor Tamanaha will speak on the perennial dialectic and a baseline theory of state law. In this especially opportune historical moment, when our students and our faculty are deeply engaged with theories of law amid this turbulent time, we are lucky to have Professor Tamanaha with us today. Before I turn the microphone over, let me make 2 very quick notes. First, Professor Tamanaha has also reserved time for Q&A following his remarks. And second, I'd like to invite everyone in the room to our reception in Auerbach Commons following the lecture. It's right upstairs on the main floor of Mondale Hall, and we hope that you will join us. Brian, welcome to Minnesota. We are so thrilled that you were able to join us today, and we are truly grateful for your generosity in sharing your time and your ideas with us today. Please join me in welcoming Professor Brian Z. Tamanaha with a big round of applause.
Thank you so much. Thank you for that introduction. I'm deeply honored to present the 26th John Dewey Lecture on the Philosophy of Law. And I want to thank University of Minnesota for this invitation. I also want to specifically thank Professor Brian Bix. Brian is widely recognized as one of the leading legal philosophers of our generation, and his jurisprudence text is the best there is. Brian's told me on several occasions that among Chinese jurisprudence scholars we're known as the 3 Brians. I'll just say I'm honored to be in Brian Bix's company. I don't know who the 3rd Brian might be. But Brian Bix is widely recognized, as I said. He's immensely knowledgeable, analytically sharp, fair in judgment, and extraordinarily generous with his time. Brian and I met at the outset of our careers as legal academics 3 decades ago, and we've been friends ever since. And Brian's helped me on many occasions in the past 3 decades, so thank you, Brian. My goal today is to present a different way of framing jurisprudence and of thinking about state law that I hope you'll find illuminating. I'm especially thrilled because my theoretical views are substantially indebted to John Dewey. Actually, coincidentally, I wrote the John Dewey entry on the International Encyclopedia of Legal Philosophy. So I share his pragmatic views about what philosophy should focus on, and I also share his view that law must be understood in consummately social terms. And these two positions underlie all my jurisprudential work. On philosophy, Dewey was highly critical of the abstract philosophies of his day that proclaimed universal absolute truths. This is a chimerical philosophical quest, Dewey argued, which pays insufficient attention to empirical reality, variations, pluralism, contingency, and the fact that all things change over time. The task of philosophy, he wrote, quote, is to clarify men's ideas as to the social and moral strife of their own day. He advocated that philosophy should help people deal with pressing problems and to reform society. Dewey was a meliorist who believed we can change the world for the better through conscious effort. Consistent with these views, I've criticized analytical jurisprudence and natural law philosophy for their quest to identify universal, immutable, absolute truths about law, which they largely produce based upon their own intuitions and conceptual analysis, while rejecting empirical studies about law. And I've argued that legal theory should help us deal with pressing problems of the day, like challenges to the rule of law. So let me give you a quick example to see the kinds of jurisprudence I'm referring to. Many contemporary analytical jurisprudence assert that coercion is not a necessary feature of law. They take this position even though, as Joseph Raz stated, quote, it cannot be denied that all known legal systems are based upon widespread resort to sanctions and that all of them rely ultimately on the use of force. Despite recognizing this, Raz concluded that coercion is not a necessary or essential feature of law because one can imagine a society of angels that would not require coercion to comply with legal dictates. This argument exemplifies what John Dewey objected to about abstract universalistic theories. Humans are not angels, and all state legal systems we know of have been backed by sanctions that include coercive force. As the late, great legal theorist Frederick Schauer, recently deceased, as he argued, quote, if we wish to understand not just the law of this or that legal system, but law generally, features that exist in all or almost all actual legal systems can tell us much about law's goals, methods, and limitations. On the second Deweyan position, viewing law as a social institution, Dewey observed, quote, law is through and through a social phenomenon, social in origin, in purpose or end, and in application. A given legal arrangement is what it does, and what it does lies in the field of modifying and or maintaining human activities as going concerns. Law, he argued, develops over time within society. For this reason, Dewey asserted, quote, law cannot be set up as if it were a separate entity, but can be discussed only in terms of the social conditions in which it arises and out of what it concretely does there. These two sets of Deweyan views about philosophy on the one hand and about law on the other inform the theoretical understanding of law that I present today. The lecture will cover 3 themes. The first theme highlights an age-old dialectic between abstract, idealized accounts of law versus skepticism about such idealized accounts. Idealized theories typically proclaim that law, state law, I'm talking about specifically, law is reason, justice for the common good, and necessary to maintain order in society. While skeptical theories typically debunk these claims by disclosing that law serves selected interests, is used to oppress people, and other problematic things. This contrast, I argue, runs through the history of theorizing about law and offers important lessons. The second theme is what I call a baseline theory of state law. Beneath surface disagreements, I argue, the majority of legal and social theorists share 5 basic propositions about the features of state law, even as they disagree about various other aspects. These are not timeless universal truths. The 5 propositions are generalizations about state laws that exist today, and all have variations and exceptions. These generalizations are drawn from natural law, analytical legal positivism, historical jurisprudence, sociological jurisprudence, and other theoretical and empirical perspectives on law. What makes it a baseline theory is simply that most legal theorists would agree with the features I identify. The third theme draws on the dialectic and baseline propositions to help analyze the rule of law in America and the challenges it faces today from actions taken by the Trump administration. Okay, let me now provide examples of the dialectic that extends back over 2 millennia. To state it tautologically, an idealized theory makes claims about what law is in highly idealized terms. Or to put it in a more informative way, idealized theories often conflate what law is with what law should be. That is, law should be just, so law is described as just. Skeptical theories castigate idealized accounts as false covers for what law really does. An early example involved a debate between Socrates and Thrasymachus in Book 1 of Plato's Republic. Thrasymachus made this provocative declaration, "I proclaim that justice is nothing else than the interest of the stronger," he said. He asserted that democracies, aristocracies, and tyrannies all make laws that advance the particular interests that they serve, not the good of all. And now I quote again, "And these laws, which are made by them for their own interests, are the justice which they deliver to their subjects. And him who transgresses them, they punish as a breaker of the law and unjust. The only reasonable conclusion is that everywhere there is one principle of justice, which is the interest of the stronger." In response to this highly skeptical declaration, Socrates, who generally held that justice is obedience to law, gave this highly idealized vision of a ruler. Quote, "There's no one in any rule who, insofar as he is a ruler, considers or enjoins what is for his own interest, but always what is for the interest of his subjects or suitable to his art. To that he looks, and that alone he considers in everything which he says and does." Thrasymachus ridiculed Socrates' statement as naive. He said it was like claiming that a sheepholder fattens sheep for the good of the sheep themselves. Philosophers disagree about precisely what Thrasymachus was asserting, but it is clear that his critical debunking was, as one theorist put it, quote, "grounded in empirical observations of the way of the world." Critical observers could see that rulers and ruling classes advance their own interests through laws they proclaim in the name of justice for all. Now, you might think that Marxists stake out a similar position in their claim that law ultimately reflects the interests of the capitalist class. But what I want to emphasize is that this position is not limited to radicals. It's been echoed across the ages by many prominent jurists, philosophers, and social theorists. The famous economist Adam Smith, who actually taught a class in jurisprudence, declared, quote, "Laws and government may be considered in this and indeed in every case as a combination of the rich to oppress the poor and preserve to themselves the inequality of goods which would otherwise soon be destroyed by the attacks of the poor, who, if not hindered by the government, would soon reduce the others to an equality with themselves by open violence." Preeminent 19th century German jurist Rudolf von Jhering wrote, quote, "Whoever will trace the legal fabric of a people to its ultimate origins will reach innumerable cases where the force of the stronger has laid down the law for the weaker." Jhering argued that an unceasing social political struggle takes place over what secures legal recognition, and, quote, "The issue is not decided by the weight of reason, but by the relative strength of opposing forces." American jurisprudential giant Oliver Wendell Holmes asserted, quote, "This tacit assumption of the solidarity of interests of society is very common, but seems to us false. The more powerful interests must be more or less reflected in legislation," he wrote. Again quoting, "Legislation is necessarily made a means by which a body, having the power, puts burdens which are disagreeable to them on the shoulders of everyone else." Another jurisprudential colossus, H.L.A. Hart, remarked that state law, quote, "may be narrow and exclusive may be a narrow and exclusive system run in the interests of the dominant group." The great Judge Richard Posner, law and economics champion, has argued that a great deal of legislation involves legally imposed transfers of wealth secured by well-financed interest groups at the expense of the general public. But we don't need theorists to tell us this. Consider the billions of dollars flowing through our political system during elections that influences who gets elected to office and shapes what laws they enact. The tax cuts passed in 2025 were substantially paid for by reducing health benefit subsidies for the poor. Or think about the nearly $300 million Elon Musk contributed to Donald Trump's successful election, followed immediately by Musk taking a chainsaw to the federal bureaucracy and cutting back on employees and regulations. Another historical example of the dialectic revolved around Anglo-American common law. Many prominent judges and theorists, including Coke, Blackstone, and many others, identified the common law with natural law, reason, and customs of the community from time immemorial. Coke asserted that, quote, the law of nature is part of the law of England and derived from God and discernible by reason. Blackstone asserted that the fact that the English common law has endured for so long is evidence that it is good and worthy, justified by its convenience and utility, consistent with natural law and reason. Prominent American jurist Jesse Root proclaimed in 1789, quote, the common law was derived from the law of nature and of revelation, those rules and maxims of immutable truth and justice which arise from the eternal fitness of things, as they are themselves the highest authority, together with certain customs and usages which had been universally assented to and adopted in practice as reasonable and beneficial. Chancellor James Kent, another giant in American law, asserted, quote, the common law, as far as it was applicable to America, was founded in natural law. The skeptical response to these encomiums was led by Jeremy Bentham's attacks against Blackstone. The common law, Bentham charged, is filled with fictions and obscurities that serve the interests of rulers and the aristocracy while lining the pockets of lawyers. Now, jurists dismiss Bentham as a crank, but people confronted with the opaque common law writ system will have appreciated his objections. Another source of criticism of idealized views of the common law focused on the treatment of women. Under common law coverture, wives were required to provide sex to their husband, property was held by the husband, their legal claims were held by the husband, earnings they obtained outside the home were controlled by the husband had final say over family matters, husbands could physically discipline their wives, and women were wholly responsible for household duties. Moreover, the common law crime of adultery was defined in gendered terms as sex involving a married woman and someone other than her husband, while married men having sex with a single woman was not considered adultery, but fornication, which had a lesser punishment. Blackstone justified coverture as, quote, for the most part intended for her protection and benefit. But women had a different view. Mary Wollstonecraft, in A Vindication of the Rights of Women, published in 1792, objected that women are held in a slavish condition of obedience to their husbands, suffering, quote, the slavery of marriage. In a remarkably candid 1871 article reviewing a book on common law coverture, the author wrote, quote, this talk about the law of nature is all balderdash. The argument, what there is of it, is the same which from time immemorial has been used to justify cruelty, extortion, robbery, the Inquisition, slavery, and every oppression which has at any time been practiced by the strong upon the weak. Aristotle justifies slavery, war, and pillage by the law of nature. The author cataloged various ways in which women are treated poorly under the common law rules that purportedly had, quote, some countenance in the law of nature which gave strength to the man and feebleness and dependence to the woman. The author contemptuously stated, quote, both Coke and Blackstone, with an offensive self-complacency, uphold and justify nearly everything in the common law treatment of wives, which has been fiendishly atrocious, and that too commonly by examples drawn from Scripture. Critical feminists writing today likewise argue that law in various ways enforces patriarchy. But famous non-feminists have also taken this point. Adam Smith, for example, commented that in many societies, husbands exercise great authority over their wives. What explains this, he surmised, is, quote, the laws of most countries being made by men generally are very severe on the women, who can have no remedy for this oppression. Observing that law often treats wives more harshly for adultery, Smith added, quote, the real reason is that it is men who make the laws with respect to this. They generally will be inclined to curb the woman as much as possible and give themselves the more indulgence. Who knew that Adam Smith was such a woke theorist? The examples I've provided suggest that jurisprudence should reconsider how critical theories are generally portrayed. The standard jurisprudential account places critical legal studies, critical feminism, and critical race theory as modern schools of thought descended from the American legal realists. This is a standard narrative in jurisprudence. But my account suggests that contemporary critical theories are just the latest iteration of centuries of skeptical challenges to mainstream idealized theories of law. The very longevity of this dialectic suggests that it contains important insights about law. One of the things it tells us is that theorists and jurists are often articulating idealized theories for the purpose of legitimation. And another thing it tells us is that reality is not only often otherwise, but not everyone is buying into these idealized accounts. Now, let me turn to articulate the 5 baseline positions. Can you turn that off for a minute? I'm sorry. I will have them come up in a moment. I didn't want you to be reading as I did it, but those are the summaries of it. So now let me turn to articulate the 5 baseline propositions, which are core features of state law. Now remember, these are generalizations, so there are exceptions and deviations from each. If I'm correct, each proposition I state should seem obvious to you once I say it. So the first baseline proposition is this: the state is the supreme authority that declares, enforces, and applies legal norms backed by coercion to maintain order in society by keeping the peace, resolving disputes, guiding conduct, and coordinating behavior. This proposition can be divided into 4 parts. Laws established by the state as the supreme authority. It's an institutionalized system that declares, applies, and enforces norms. It's backed by coercion, and it functions to maintain order in a variety of ways. Most theorists would accept these generalizations about state law, though aspects of it are disputed. My own work on legal pluralism, for example, challenges the claim that state law is supreme, as well as the claim that law routinely guides the conduct of citizens. But as a general proposition about state law, this first proposition captures the basics. The second proposition is this: law is integrated within society and evolves over time in connection with surrounding social, cultural, economic, political, and technological changes. There are 2 parts to this assertion, which I call holism and historicism. Holism focuses on the interconnectedness of law within society in a mutually constitutive relationship. That is, surrounding social influences permeate law, and law permeates and undergirds social interaction. If you wonder what it means to say that law constitutes social relations, let me give you a simple example. Enabling acts create corporations with legal personality that undertake actions in the world. And corporate laws establish ownership and management of the corporation's rights and duties. In addition, corporations use contracts for their internal relations with their employees, as well as their external relations with suppliers of material, banks for financing, and commercial relations with customers. Thus, the very existence of corporations and their internal and external relations are legally structured. And in this and many other ways, law constitutes relations within society. Theorists have often asserted that law is a mirror of society. Montesquieu was the theorist that really put this out there first. But since then, many theorists have repeated this. As preeminent legal historian Lawrence Friedman put it, quote, "Legal systems do not float in some cultural void, free of space and time and social context. Necessarily, they reflect what's happening in their own societies." Or as Holmes put it, quote, "The felt necessities of the time, the prevalent moral and political theories, intuitions of public policy, avowed or unconscious, even the prejudices which judges share with their fellow men, have a good deal more to do than the syllogism in determining the rules by which men should be governed." H.L.A. Hart put it this way, quote, "The law of every modern state shows at 1,000 points the influence of both the accepted social morality and wider moral ideas." Now, it's because law is interconnected within society that Dewey asserted, quote, "Law cannot be set up as if it were a separate entity, but can only be discussed in terms of the social conditions in which it arises and out of which it concretely does there." Holism was the centerpiece of sociological jurisprudence, advocated by Roscoe Pound and others at the start of the 20th century. Historicism focuses on the fact that law evolves over time in connection with surrounding developments in society. As society changes culturally, socially, economically, politically, and technologically, law changes with it to meet new circumstances, challenges, and objectives. Oliver Wendell Holmes stated, quote, "The law embodies the story of a nation's development through many centuries." These themes were taken up in historical jurisprudence, which was highly influential in the late 19th century. The standard narrative in legal philosophy today is that sociological jurisprudence and historical jurisprudence expired over a century ago. Nonetheless, the underlying propositions they centered on are largely taken for granted today. Few theorists would deny that law is integrated within society and evolves over time in conjunction with surrounding developments. The main exception to this proposition is that a great deal of law is created through transplantation or borrowing. But even in these circumstances, the mirror thesis holds, since it's commonly observed that transplanted laws typically do not work the same way, owing to different surrounding conditions in the receiving society. The third proposition is this: law is an instrument for social ends. Although we take it for granted today that law is an instrument for social ends, it was not always seen that way. Prior to the 19th century, law was understood to be based on reason, natural law, and custom from time immemorial, and jurists asserted that legal concepts and doctrines had their own integrity. That is why it was often said that law was discovered or found rather than made. The rise of the instrumental view of law in the course of the 19th century coincided with the modern increase in legislation dealing with new social, economic, political, and technological issues thrown up by the rapid growth of industry, commerce, and mass urban societies. This same period also witnessed the rise of legal positivism as a jurisprudential school centered on the proposition that law is declared at the will of the sovereign. In other words, legal positivism, legal instrumentalism, and the proliferation of legislation were mutually reinforcing developments in the 19th century that ushered in the modern society and coming explosion of modern law. Early in the century, Jeremy Bentham advocated that law is a means to maximize aggregate happiness over pain in society. Later in the century, Rudolf von Jhering wrote a book called Law as a Means to an End that shows how law is used instrumentally by individuals and social groups to achieve their objectives. At the dawn of the 20th century, this position, called the social engineering view of law, was advocated by Roscoe Pound, the pragmatists, including Dewey, and later by the legal realists. As John Dewey embraced it, quote, "Now it is true that social arrangements, laws, institutions are made for man, rather than that man is made for them. They are means and agencies of human welfare." Much of today's massive administrative state involves instrumental uses of law. But these ideas also created a profound problem that we live with today. Theorists and jurists advocated that law is an instrument to serve the public good. The problem is that during the course of the 20th century, the view that law is an instrument became widely accepted, but at the same time, it became increasingly difficult to agree upon a shared public good. What resulted is a continuous battle that we see today over law within legislatures and courts by groups seeking to control and use the law to pursue their own vision of the good. This now goes by the name of lawfare. The fourth proposition is this: legal systems operate through highly specialized, comprehensive bodies of legal knowledge and practices maintained by jurists and carried out by professional lawyers and judges. Legal theorists today often neglect this point, though this view of legal knowledge was a part of the understanding of the common law. This was also the focus of the eminent sociologist Max Weber, who was trained in law and actually taught jurisprudence as well. Weber emphasized that modern law is a formally rational system based on a comprehensive set of logically organized legal doctrines which are maintained by professional jurists. Consider that when statutes are enacted and applied, their meaning is interpreted within an extensive backdrop of legal concepts and doctrines, rules of interpretation, and other aspects of legal knowledge and practice that are not stated in the legislation itself. Consequently, all positive lawmaking presupposes and acquires meaning within the broader body of legal knowledge and practices. And the actual operation of the legal system is carried through by private lawyers and people trained in law working in government offices. I should also add that Weber noted, like Bentham, that lawyers benefit financially from their monopoly position in the operation of the legal system. Law schools are the primary locus of the fourth feature. Law professors develop legal knowledge and impart this knowledge and professional norms to students. Later, I'll explain why this feature is pivotal to the rule of law. The final proposition is this: legal systems regularly enforce the power of government, serve selected interests, enforce domination, and oppress citizens. Many theorists have pointed this out, as I started saying at the beginning of the talk. A prominent historian of early states, Henri Clausen, remarked, quote, "There's always found great inequality in early societies. Some people, the happy few, are rich and powerful, and all others, the great majority, are poor and powerless." Law maintained this arrangement. Many societies throughout history, including today, exhibit the same pattern. Keep in mind that slavery was legally enforced for over 2,000 years, from classical Rome to antebellum America. These dangers are inherent to state law because officials with lawmaking power can declare whatever content of law they choose, and their legal determinations are backed by force. This was pointed out by Hart, quote, "So long as human beings can gain cooperation from some to enable them to dominate others, they will use the forms of law as one of their instruments. The economic resources, organized legal powers, and coercive force the government wields always pose a parlous threat to the populace." Throughout history, we see many examples in which law favors certain groups over others: the nobility and priests over commoners, masters over slaves, men over women, higher social classes over lower social classes in stratified societies. In capitalist societies, the capitalist class over workers, whites over blacks, Christians over Muslims, or vice versa, and many more. As Hart wrote, the legal system, quote, "may be used to subdue and maintain in a position of permanent inferiority a subject group whose size, relative to the master group, may be large or small, depending on the means of coercion, solidarity, and discipline available to the latter, and the helplessness or inability to organize of the former." It's essential to recognize that above all else, government uses law to protect itself. Special rules protect government officials carrying out their actions. For example, laws against sedition, laws that make it a crime to lie to a public official, laws that provide immunity for police officers for their actions. Adam Smith wrote, quote, "Those threats which immediately affect the state are those which will first be the objects of punishment." There's no need for me to tell an audience in Minnesota about the potential dangers to citizens posed by legal officials armed with weapons, as people here experienced firsthand when gun-toting ICE agents flooded your streets. But on a much vaster scale and of many magnitude degrees worse, consider North Korea or Russia today, where legal systems harshly punish opposition to the political regime, including imprisonment and death. While many theorists have recognized these aspects of law, including Hart, nearly all of them characterize this as an abuse of law rather than a feature of state law. But Bentham insisted, quote, "When a thing has various effects, some good and some bad, it's not by calling the bad by the name of abuses that will make them the less its effects than they were before. An abuse is a bad effect. Now, a bad effect of a thing is as much its effect as a good one." Or as John Dewey put it, quote, "A thing is defined as what it does. What it does being stated in terms of specific effects extrinsically wrought in other things." Or to put it more simply, law is what law does. And state law everywhere has enforced domination over some over others in various ways. And therefore, it is a feature of state law. So Randy, can you put up that slide for me for a moment, please? So I wanted to put these up because I said a lot of them, but I'll just repeat them quickly. And this is just abbreviated. Laws are created, applied, and enforced by the state using coercion to maintain order. Laws are integrated within society and evolve over time in connection with surrounding developments. Law is an instrument to serve social needs. Legal systems operate through legal knowledge maintained by jurists and the actions of lawyers, and legal systems regularly maintain the power of government itself, serve selected interests, and maintain domination and oppress others. By the way, if you're wondering what that blue thing is, let me just tell you, I don't know about other philosophers, but I've never used PowerPoint. So I opened up the PowerPoint slide for the first time, and I couldn't figure out how to get rid of the blue line. I confess my inadequacies. All right, so these are the 5 propositions. They capture core features of state law, and they provide resources for evaluating many theoretical and empirical questions about law. If you find all 5 propositions persuasive, then you might be surprised to learn that contemporary jurisprudence primarily revolves around the first proposition. Jurisprudence largely neglect the 2nd through 4th, and the 5th proposition is recognized, but they're categorized as critical theories which are placed on the side, but not really as a central feature of law. Now let me turn to the 3rd topic. I'll draw on these propositions to say a few things about the rule of law generally, and then more specifically about the Trump administration. As I said at the outset, Dewey argued that philosophy should help us understand and deal with the pressing problems of the day. And I'll show you how the theory I laid out helps us do this. So put simply, I'm going to summarize some basic ideas about the rule of law that I think are generally shared. The rule of law ideal holds that government officials and people are bound by the law. The rule of law requires that the law be set forth publicly in advance so that everyone has notice of its specifications. And it requires that the law must be applied equally to everyone according to its terms, no matter who they might be, friend or foe, rich or poor, government official or layperson. The primary focus of the rule of law is to limit the abuse of power by holding government officials to act in accordance with the law. Government officials must have advanced legal authority for their actions, and their actions must not violate existing legal restrictions. This restrains government officials from taking arbitrary actions based on personal whim, passion, prejudice, and so forth. And it enhances individual liberty by advising people of what they're free to do without fear of government sanction, and by providing predictability about the legal consequences of their actions, which enables people to plan. So the 5 propositions I just mentioned tell us various kinds of things about the rule of law, and I just want to give a couple examples. So for example, if you want to know why the rule of law is necessary, the answer is that it applies legal constraints to help contain some of the dangers to people posed by government itself, as I highlight in the 5th proposition. A lawless government is more dangerous to people than a government that follows the rule of law. Though keep in mind that this is not a complete solution, since government can also use law to enforce tyranny, as with slavery laws, which the rule of law does not necessarily prevent. If you want to know how the rule of law developed in our society, the answer would be found in the 2nd proposition about the historical evolution of law within society. If you want to know how the rule of law operates, the answer is that we have created a constitutional separation of powers with independent courts that hold government's officials to comply with the law. And this separation is implicitly contained in the 1st proposition, which specifies that the state enacts law, that's legislation, enforces law, the executive, and applies laws, courts. Okay, so those are just some general examples of where you look to within these propositions to answer some of these questions. But now I want to say something deeper and then use the Trump administration as the basis for making this statement. The Trump administration has engaged in a broad swath of actions that press against the outer boundaries of law into outright illegality. From imposing tariffs based on an emergency law that does not authorize the president to declare tariffs, to sending the National Guard into cities without legal justification, to deliberately killing people on boats in the Caribbean and the Pacific, although domestic and international law do not permit such killings. There's vastly more that I do not have time to list, though if you're interested, I have an essay on SSRN entitled Lessons Learned from the Trump Rule of Law Stress Test. Here I want to focus on 2 challenges to the rule of law, one of which has received a lot of attention, and the second of which has received less attention, but is just as important. The first challenge is the administration's vicious attacks on judges who render adverse rulings, false statements to judges, and outright defiance of judicial orders. The most recent criticisms came in response to the Supreme Court decision striking President Trump's tariffs. Trump called the judges in the majority, quote, fools, lapdogs, a disgrace to our nation, swayed by foreign interests. This outburst was just the latest of many attacks against judges by Trump and his officials in the past years. These attacks were taken to an unprecedented level when the administration literally sued all of the federal district judges in Maryland over their response to the deportation orders. Retired federal judge Michael Luttig, a lifelong staunch conservative, called the suit, quote, reckless and irresponsible and yet another frontal attack on the federal courts of this country. District Judge Thomas Cullen, who was appointed by Trump himself, dismissed the case, writing this sharp condemnation, which I quote from his opinion. Indeed, over the past several months, principal officers of the executive and their spokespersons have described federal district judges across the country as left-wing, liberal, activist, politically minded, rogue, unhinged, outrageous, overzealous, unconstitutional, crooked, and worse. Although some tension between the coordinate branches of government is a hallmark of our constitutional system, this concerted effort by the executive to smear and impugn individual judges who rule against it is both unprecedented and unfortunate. Judge Cullen, let me repeat, was a Trump judicial appointee. In addition to verbally attacking judges and suing them, Trump administration officials have in multiple cases made demonstrably false statements to judges. Law professor Ryan Goodman, part of a team tracking lawsuits against the Trump administration, identified over 35 cases in which judges specifically said that the government was providing false information. That tally was made 2 months ago, so the number is greater now. For instance, Judge Karen Immergut, a Trump appointee, found that Trump administration officials' claims that deployment of the National Guard was necessary in Portland because Portland was chaotic and burning. She stated that it was simply not credible. Although Trump characterized Portland as war-ravaged when ordering the deployment, Judge Immergut found that, quote, the protests were small and uneventful in the weeks immediately preceding his order. Again, quoting, the president's determination was simply untethered to the facts, she held, and therefore lacking legal authorization. Another remarkable instance of false statements to judges occurred when the Trump administration planned to deport 600 unaccompanied minors back to Guatemala. They claimed that the minors were not being deported, but instead were being, again, reunited with their parents, so there was no need for legal deportation proceedings. They were just going to take them out of the country. Federal District Judge Timothy Kelly shredded this claim, and I'm quoting from his opinion. All defendants wanted to do, they claim, was reunify children with parents who had requested their return. But that explanation crumbled like a house of cards about a week later. There was no evidence before the court that the parents of those children sought their return. To the contrary, the Guatemala Attorney General reports that officials could not even track down parents for most of the children whom defendants found eligible for their so-called reunification plan. And none of those that were located had asked for their children to come back. Judge Kelly, another Trump judicial appointee, explicitly stated the government was acting in bad faith. The criticisms that I've cited from Judges Cullen, Immergut, and Kelly are obviously not partisan judicial attacks on the Trump administration, given that all three judges are Trump judicial appointees. But that's not protected judges from being savaged by Trump officials in response to their adverse rulings. In addition to attacking judges and making false statements in courts, administrative officials have repeatedly defied judicial orders, and the best example of this is in Minneapolis. Federal District Judge Patrick Schultz, a former law clerk to Justice Antonin Scalia, sharply rebuked ICE for repeatedly failing to comply with judicial orders. Judge Schultz attached an index identifying 96 court orders that ICE violated in 74 cases, and he made this statement, quote, this list should give pause to anyone, no matter his or her political beliefs, who care about the rule of law. A spokeswoman for the Homeland Security dismissed Judge Schultz's opinion as, quote, a diatribe from this activist judge. A recent New York Times report found 35 instances in which a district or federal magistrate judge have issued show cause orders against the Trump administration officials to explain why they should not be held in contempt for violating court orders. That's 35. It's extraordinary. I could give many more examples of vicious attacks, false statements, and refusal to follow judicial orders, but the point is made. Attacking judges, lying to judges in court, and defying court orders is a frontal assault on the rule of law. I'm relieved to say that thus far the federal judiciary has stood up remarkably well to this sustained assault. But the second challenge to the rule of law is the assault on private and governmental lawyers who might stand in the way of the Trump agenda. And on this score, we're not doing that well. In fact, I believe this assault has been highly effective and is doing real damage to the rule of law. First, I must emphasize that lawyers are essential to the rule of law because lawyers must be willing and able to challenge the actions of government officials if the government is to be held accountable to law. And this is precisely what the Trump administration has targeted. First, he took on private lawyers. Soon after entering office, President Trump issued executive orders that attacked several elite law firms, canceling the security clearances of lawyers, terminating their contracts with government officials, barring access to federal courts, among other sanctions. These punitive actions would disable the lawyers from being able to serve their clients, and it also would financially devastate the law firms. The targeted firms immediately lost business owing to the orders. Several of the targeted firms, along with several law firms that feared they might be targeted, entered agreements with the Trump administration that collectively promised to provide $1 billion in pro bono services, which Trump claimed he was free to use for any purposes, including for himself. Meanwhile, the 4 law firms that challenged the orders prevailed in court on multiple grounds, including that the orders violated free speech, due process, and equal protection rights of the lawyers, as well as the client's rights to counsel. In the case involving Perkins Coie, Judge Beryl Howell stated, quote, "Settling personal vendettas by targeting a disliked business or individual for punitive government action is not a legitimate use of the powers of the U.S. government or an American president. Our Constitution leaves no room for the exercise of purely personal and arbitrary power." In the case involving Sussman Godfrey, Judge Ali Khan stated, quote, "The order threatens the independence of the bar, a necessity for the rule of law." Despite being struck down, the orders had their desired effect. Succumbing to Trump's intimidation, large law firms, quote, "have chosen to avoid high-profile pro bono cases out of fear of angering the president." A study in the Washington Post found that large law firms represented plaintiffs in 15% of the cases challenging the Trump administration executive orders between the start of his term in January and September. 15%, 15%. Compared with roughly 75% of the cases during a comparable period of the Trump first administration. In other words, they brought 75% of the cases, and now they brought 15% of the cases. This is a dramatic drop in suits by firms that have some of the best lawyers in the country, and more importantly, or just as importantly, ample resources to bring cases. This drop is especially harmful given the fact that the second Trump administration has been far more aggressive in pushing against the outer boundaries of law than the first time around. Now, that's bad, but an even more deleterious threat to the rule of law has been the systematic removal of lawyers within government who raise any objections to Trump administration policies and actions. This has occurred within the Department of Justice as well as within departments and agencies across the government. For example, it was reported that Secretary of Defense Pete Hegseth removed JAG lawyers from prior review of the legality of the missile strikes on boats. Hegseth fired the top Army, Air Force, and Navy lawyers, calling them, quote, "roadblocks to orders that are given by the Commander-in-Chief." This is a deliberate action to evade the rule of law in military operations. Another example occurred when a U.S. attorney appointed by Trump, Eric Siebert, refused to prosecute former FBI Director James Comey and New York Attorney General Letitia James owing to a lack of evidence that they committed a crime. President Trump publicly demanded on Truth Social that Comey and James, among other targets, be prosecuted. He then fired Siebert, appointed his personal attorney with no experience in criminal law, Lindsay Halligan, who immediately complied with his demand and brought charges against Comey and James. Both counts were later dismissed by judges on the grounds that she had been improperly appointed. These events make clear that any lawyers who refuse to comply with Trump's desires will be fired and replaced by people who will, even when the law does not support these actions. Many government lawyers have been fired or resigned rather than carry out directives they believe are contrary to the law. And that is exactly what they should do. However, it looks like they're being systematically replaced by lawyers like Halligan who are willing to do the president's bidding even when contrary to the law. This is an extraordinary situation. In the words of Harvard law professor Jack Goldsmith, a highly respected conservative scholar who worked on the Office of Legal Counsel for the Bush administration, I quote, "an atomic bomb dropped on the department." He explained, quote, "There are tens of thousands of lawyers in the massive executive branch spread out whose job is to ascertain the massive array of laws that are supposed to govern executive branch behavior. And you can be cynical about the system, but it's always worked, including with the Justice Department, in keeping the White House and the senior executive agencies more or less within the law, with some exceptions. And this administration has systematically and ruthlessly and successfully eliminated, with one exception, all internal legal resistance. It's simply not acceptable to offer an opinion contrary to the one that the president, who's not a lawyer, wants to push. It's really an extraordinary thing. It's really an extraordinary thing. This is crucial to understand this point he's trying to make. Although unseen from the outside, innumerable decisions are made daily by government lawyers that keep the government within the law. Since judges ultimately review only a tiny fraction of this, and often belatedly, compliance with the law in the first instance and in the overwhelming majority of instances depends heavily on good faith determinations by lawyers in government positions of what the law requires. Now I'll go back to my earlier discussion to discuss the actions of the Trump administration and illustrate for you some of how we can use these baseline features. So the concerns that I've raised about lawyers and the rule of law relate most fully to the fourth feature. That is, legal systems operate through the actions of professional lawyers. Although this feature of state law is generally neglected in jurisprudence, this situation shows that it's essential to the proper functioning of state legal systems. The fourth feature directly bears on the two challenges to the rule of law that I've raised. The judges who steadfastly apply the law to restrain the actions of the Trump administration are drawing on legal knowledge, legal doctrines, and professional norms and practices in their ruling. Above all else, the commitment to abide by the law. Rule of law theorists typically emphasize independent courts, but what they often omit to mention is that the independence of courts and legal decisions by judges are themselves dependent on legal knowledges and practices maintained by jurists generally. They're dependent on lawyers bringing case to court, and they're implicitly dependent on lawyers advising government officials to prevent legal actions from occurring to begin with so that courts don't have to deal with them. The intimidation of private lawyers and the removal of government lawyers committed to faithfully applying the law is directly aimed at removing rule of law constraints on government officials. These events reveal that the ultimate preservers of the rule of law are legal professionals committed to upholding the rule of law. This is also why it's essential that state bar associations maintain their independence as guardians of the lawyer's commitment to legality, sanctioning lawyers who fail this commitment. This brings me to my closing comments. As I mentioned earlier, legal education, law schools, are the primary locus of the fourth feature. Law schools are where legal knowledge is developed and professional norms are taught. Law schools are where aspiring lawyers are taught that they have an obligation to comply with the law, be truthful to courts, obey court orders. Law schools are where young lawyers learn that if you work within the government, your primary commitment, the oath you take, is to uphold the law, not to do whatever the leader demands. The challenges posed by the Trump administration are a reminder that we cannot take the rule of law for granted, and that above all else, lawyers, us, lawyers, are ultimately responsible for maintaining the rule of law in our country. Our mission as legal educators is to teach students that we must be highly critical of state law, to reveal when law is being used to do bad things, and to reform law for the better, to serve the common good. That is the lesson of the perennial dialectic I described at the outset. At the same time, we must teach students that a pivotal part of the professional role of lawyers is a commitment to uphold the law. We must be critical of the law and committed to the law at the same time. It's not always easy to maintain both, but it can be done, and the functioning of our legal system depends on it. Thank you for listening.
Okay, thank you very much. My name is Logan Barr, and my question is, so given the underlying skeptical framework, how do we get to that the thing we should draw from this is to protect the integrity of the fourth feature? Isn't there a way of looking at the current systemic and consistent attack on the fourth feature as the actions of the first three and the fifth working in concert to try to change the fourth feature. Can't we understand this as just if there is no natural law, like should, for what law should be, can't we understand this as just a changing of the guard and regime towards a new aim for what law is?
If you're saying that the Trump administration is the changing of the guard for what law is?
It seems like,
yeah.
unfortunately, they keep making these effective attacks.
Yeah. I'm not sure, first of all, let me go to your first question. I think you're right in the sense that all five features are jumbled together in this. I think you're also right to say that there's a kind of skeptical undertone to the framework that I'm serving, that I'm presenting. But the skeptical undertone is one that's balanced out by idealism. And I think it's important to hold both of them together, everyone. In other words, I think ideals are important, idealized theories of law. I would just say rather not be passed as descriptively accurate. We can talk about what law should be, and then we can talk about how law is not meeting that. Lots of the theories that I'm talking about that were criticized weren't saying that law should be reason and natural justice. They're saying law is reason and natural justice. So that part I'm objecting to. But I'm not objecting to the idea that we should always espouse high ideals for law. Justice, the common good are fundamental. And then what happens on the ground, and this is where I cited von Jhering, are just continuous battles within society for us finding ways in which we can create a system of law that people find that works, is good, satisfies their desires. But it's a never-ending battle. So I'm agreeing with you about the dynamic component of it and how they all relate together. In relation to the Trump administration, I don't see this as sort of them becoming what the law is, because their whole approach is we don't actually care about law. So it's not going to be a replacement for law. It is law doesn't matter. It's just a hindrance, as I read the quote from Hegseth. It's just a hindrance. Now, that is not going to be the rejection of law is not a replacement image of what law is. It just says, if I want to get something done, then the law is something I'm just going to step on. If that path is taken, then we'll be in a very serious situation. I don't actually project that will happen. I'll say one thing about the rule of law. Some quip was made by some theorist, I'm forgetting his name. The point about the rule of law is the hard part was the first 5 centuries. I think the point about the rule of law is, although we can't take it for granted, it has its own resilience. There's a sort of self-perpetuating element to it. By the way, the resilience for the rule of law, my message that I was trying to get through is here. It's in this room. It's in this building. It's us inculcating these commitments. When I took an oath, I was a public defender. When I took an oath to follow the law, I know maybe I was stupid, but I meant it. And I feel like we should all have that, even as we're critical. I was a public defender. I was opposing the government, but I still took an oath to uphold the law. So I want to give a little bit more of a balanced vision, maybe than the one that you took away. It's about ideals and criticism and a constant, I don't even want to say fight, let's say struggle within society between all of these dynamic elements.
Thank you very much.
Hi, Brian. We haven't met yet. I'm Amna Akbar. I just joined the faculty here. So I have 2 questions. One is, and I might just be I might have missed something, but I didn't completely understand what's the relationship between the account of the features of state law, where you're aiming to articulate something at the level of descriptive rather than idealized variety,
Right.
and the rule of law, which as you articulated it, I hear partly as an idealized articulation of law.
Right.
So I wanted to kind of try to understand if I'm missing something there or what you're seeing as a relationship between those 2 things. And then the second question, on a different register, is, in the end of the talk and right now in response to the last question, you were emphasizing the importance of law schools and you said something like the rule of law depends on the profession.
Yeah.
And I guess I'm just wondering, being here in the Twin Cities, what you see as the role of the people in the rule of law.
Okay, so let me answer the second one first. Rule of law, so there are continuing and many debates over what the rule of law is. It's another one of those essentially contested concepts. So I tried to give basically a pared down version. The rule of law is really a political ideal. It's not a law. The rule of law is not a law, right? It's an ideal. And that ideal is that people and government officials are generally bound by the law. That's the basic ideal in a summary of it. Now, the ideal is an ideal that jurists hold, but that ideal is an ideal that has to be anchored within society generally. If the society doesn't support the law, you cannot have the rule of law. And by the way, there are many societies struggling to get the rule of law around the world today, and they're having great difficulty doing it, in part because they didn't have the same development in the second proposition over time integrated within society. But the other reason they're having difficulty is that their legal systems are patently bad. So why would a society want to uphold the law or feel like they're legally bound if, for example, the legal officials are corrupt or crooked, or the law is supporting only one group within society? So there are societies trying to develop the rule of law, but it can't really get a toehold in there because the society at large just don't believe that the law is worthy of being something that people are bound by. So the rule of law depends, and again, I'm answering your second question, on a general social attitude that's supportive of compliance with the law. In relation to the first question, I'll say you described that very well. So the 5 features for me are just descriptive generalizations. And as I said, I just took them from what theorists have been saying. And all I'm trying to say is we know a lot about law if we just look at these 5 propositions and then explore them, unfold them, and tell us what they tell us. But I also said when I said it, these are just generalizations and there are exceptions, and I gave myself as an exception. I have criticized a couple of those propositions, even though I think by and large it's a good description in most places, not everywhere. How the rule of law relates to that is that those are descriptive propositions. The rule of law is an ideal. That's basically the point. I'm talking about that ideal. I'm saying, how did that ideal emerge? Feature number 2. How does it work? Feature number 1 and number 4. So I'm just using the features to tell us things about that particular ideal. Thank you.